This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hivner. And on behalf of Judge Bennett and Judge McGee, we welcome all four counsel to this oral argument, which we are live streaming in order to fulfill our obligation to maintain open courts. The appellants have 15 minutes and the appellees have 15 minutes. And I understand you have agreed to divide your time equally, and the appellants have reserved specific minutes for rebuttal. And there being no announcements, I'll ask Mr. Hivner to call the case.
Re Khalil J.
All right, we'll hear from the appellants.
And that would be me first, I believe. Good morning, Your Honors, and may it please the court. My name is James Rose. I represent Dusty Lynn Hayes, the appellant mother in this case. As we all know, termination of parental rights is a very serious and grave matter which all courts, trial and appellate, should take very seriously. This case presents many, many tough circumstances and some clients who have been through a lot. In this case, it may not be the best looking set of circumstances. It may not be the most advantageous of people, but these are people who have tried very, very hard and worked very, very hard, as I've stated in my brief, to try to get their lives together to parent. According to statute, my client, Dusty Hayes, being the mother of unwed parents, of being the mother of a child born to unwed parents, had the custody, and it was immediately taken from her. The record also indicates that she lost two other children, but that she would fight tooth and nail to keep this child and to work hard to keep this child. She did so working on parenting classes, anger management, domestic violence classes, and struggling with hard conditions such as ADHD. The trial court selected three of the statutory grounds, which the court is very aware of: 36(1), 113G. 1, the condition still existing in her home; 2, mental incapacity; and 3, failure to assume legal and physical custody or financial responsibility of Khalil. We are asking the court to reverse this case and this ruling. The persistence of conditions, she was working hard, very hard during a very tough COVID-19 situation for many parents. On the ground, we have seen that this pandemic, and again, I know, as I stated in trial, I know that I'm walking up a slippery slope. It's been a tough time for a lot of people, both health-wise and logistics-wise in court. But I've heard the cries of parents who are trying to get their lives together. And when court is moving slowly, sometimes that presents an issue. Again, moving back to my point, we have persistence of conditions, but she was working hard on permanency plan under 3 different workers and was stopped, as I said, at the proverbial finish line. Also, the impaired mental condition. More efforts should have been made to try the behavioral therapy, which Dr. Janie Berryman testified about. It's just like changing a light bulb. If the light bulb wants to change, the light bulb indeed can change. That effort wasn't made. There were some assessments that were performed, but they were not followed up on, and the behavioral therapy was simply not tried.
But didn't Dr. Berryman say that mother could not independently parent?
I believe she may very well have said that, but I believe that more effort should have been made. I believe, again, with the light bulb, when the light bulb wants to change and can change, we should have had more effort to change it. It's also very difficult to visit during this time when you're having to visit on video. I quoted
Mr. Rose, I believe the child in question here was born in January of 18. Is that correct?
Yes, Your Honor. January of 18, immediately removed pretty quickly, like within 2 days.
And then the petition to terminate parental rights was filed in November of 19, correct?
That's correct, Your Honor.
And so am I understanding you in your argument here to say that the mother was unable to complete various requirements due to COVID-19?
No, Your Honor. What I'm saying is the visitation was very difficult. She was able to complete, the record indicates that she completed parenting classes, anger management, domestic violence classes, and had income through SSDI. So no, Your Honor, that's not correct. That's a great point, but that's not what I'm saying. What I am saying though, is that visitation was made extraordinarily impossible or not practical due to COVID-19, because for a whole year, you weren't able to see your child. You weren't able to bond with your child. I would be remiss if I didn't go through that, bring that argument before the court. And again, it's a tough argument. So on one hand, we might have had, the permanency plan might not have been exactly, every I might have been dotted, every T may not have been crossed. But at the same time, you couldn't visit your child. You only had to visit your child during video. In my mind, video visitation between a parent and child is essential. And if it cannot happen, if it has to happen over video, it's almost impossible to keep the bond with your child. So we're asking for the court to reverse this decision as to Dusty Hayes.
Thank you, Mr. Rose. We'll now hear from Ms. Mack on behalf of the father.
Good morning, Your Honors. On behalf of Mr. Henry Jordan, our position has been and remains the same, that Mr. Jordan was never given a chance. He was never given a chance to father or parent this child because the child was literally removed from the hospital on day 2, right after the birth of the child. As my colleague just stated to the court, that the child, the mother was in the custody of the mother. And so the court ruled that my client had persistence of conditions. My client had the incompetence in regards to that. And so I focused in my brief that I wanted to focus on Shannon Walls, the testimony of Shannon Walls, as well as Dr. Berryman in regards to what should have happened in 2018 prior to the pandemic. And we've heard consistently during the trial that we had inconsistent case management in regards to that. And the only thing that was consistent during that time was Shannon Walls. Shannon Walls, in the state's brief, they replied that Shannon Walls provided therapeutic visitation, and that's not accurate because Ms. Walls testified all she was doing was supervising the visits. I asked Ms. Walls during the trial, did anyone from DCS or any other agency, did she consult with Athena, any of the service providers that were providing these recommendations in regards to the father? Did anyone consult with her? And she stated no. No one made any other recommendations, changed or modified these recommendations. So then we enter into 2020 when the pandemic hits. Ms. Shannon Walls then begins to provide only virtual visitations. It came out in trial during that time is that these virtual visitations with this child could have been face-to-face. However, Ms. Walls didn't have any guidance other than what the department requested for her to do. During our litigation of this case, Judge Calloway ordered the department to begin separate visitations with these parents to make sure that we could get the information that we needed. So the department at that time separated these visits 1 hour at a time with each parent. Even prior to that, the visits with Ms. Shannon Walls, the testimony was clear during the trial that the visitations were together with the parents. Dr. Janie Berryman testified that should a person with the low functioning, she did not say he could not parent a child. He said he would need some help with the heavy lifting. And what should have been done in the beginning was the services provided, supervising the visits, making recommendations at that time, and then towards whether or not we should progress. That in this case never happened. And we have been simply asking this court to remand this case for those services to be provided for Mr. Jordan. I get that Dr. Berryman basically stated that at the time of trial, it had been so long that the child does not know the father. And my client acknowledges his child doesn't know him, but he was never given the chance to develop that bond because the services that were needed, even with Athena didn't evaluate the father or the child together when it made its recommendations. every service that was recommended, the father followed through with. And then the state even stated that there was some confusion that for the father to understand what else needed to be done. There was a core communication in regards to that, but not to even communicate as a team with the service providers, the agency providers for next steps in this case. I asked Ms. Walls while she was on the stand, did anybody from the Department of Children's Services, FSW, or even her supervisor make any recommendations for her to either move forward or move backward? She said she never consulted with the department. All she was doing was providing supervised visitations. She didn't even give recommendations. She said that was not her job. So it's our position that the services that should have been provided were not provided. And this case needs to be remanded back down and order DCS to provide the services that are needed in this case that wasn't given prior to this petition for termination of parental rights being filed, Your Honors.
All right. Thank you, Ms. Mack. We'll hear from you and Mr. Rose on rebuttal.
Thank you, Your
Hear
Honor.
from the appellees.
May it please the court. Good morning, Your Honors. My name is Amber Barker, and I represent the Department of Children's Services in this appeal. Your Honors, this case involves two parents who, despite efforts by DCS and having 3 years prior to trial to work towards reunification, were wholly unable to care for the child at the time of trial. The trial court's decision terminating their parental rights should be affirmed because, first, the termination grounds were established by clear and convincing evidence. And second, termination of their rights was in the child's best interest. So as previously stated, there were 3 grounds for termination that were found by the trial court here. The first was failure to remedy persistent conditions that prevented reunification, which is ground 36-1-113-G3. As this court is aware, there are generally about 4 elements that have to be shown for this ground. The first was met here. The child was removed from the parent's care in February 1st of 2018. He was only a few days old at the time. DCS did file a dependency and neglect petition in that proceeding, and the termination trial was first set to begin in 2020, which was certainly more than 6 months following the 2018 removal. The second element, there were still conditions present at trial that prevented reunification with the parents. Mother was homeless at trial, and she admitted to using and had tested positive for cocaine in just June of 2021. She missed a couple weeks of in-person visitations before the last day of trial, and she couldn't be reached by DCS or Meharry Medical during that time to arrange an alcohol and drug assessment. For father, he also admitted to using drugs in June 2021, and he failed to show up for a scheduled drug screen following that admission. He refused an alcohol and drug assessment by Meharry. He missed the June 2021 Child and Family Team meeting, and he told DCS that he was not going to do anything else on the permanency plan, that he was done. The third element, there is little likelihood that the conditions would be remedied soon to allow for safe reunification. It had been 3 years by the time of trial since the child had been removed from these parents. Even at trial, mother still blamed other people for the child's removal, and father still blamed others for not being reunited with the child, and he still did not understand why he did not have custody. In fact, father was refusing services at the time of the last day of trial and said he wouldn't do anything else, so it did not appear that either parent would make the changes soon. And then finally, continuing the parent's relationship with the child would diminish the child's chances of integrating into a safe and stable home. The child had emotional outbursts before and after visits, and that continued even when the in-person visitations resumed in 2021. And the child cried and was very nervous about visiting with the parents. The foster mother was his comfort. There was no indication that the child had any bond with the father. The father didn't believe that the child was bonded with him. And the foster home was the only home that this child had ever known. He was thriving in foster care, and the foster parents wished to adopt him and give him the stability that he needed. The second grounded issue is the ground of mental incompetence, which is 36-1-113-G8. There are 2 general requirements for this ground. The first, that the parent is incompetent to care for and supervise the child due to a presently impaired mental condition. And second, that condition would remain impaired so that it's unlikely the parent would be able to assume care and responsibility for the child in the near future. In this case, Both parents had extremely low IQ scores, which put them in the mild intellectual disability range. Mother was first assessed in 2012 and again in 2019, and she was assessed at trial by Dr. Berryman, who testified as an expert in the field of psychology. Mother had several other mental health issues, and throughout the custodial episode, she was receiving continuous treatment for unspecified depressive versus bipolar disorder. Dr. Berryman testified that mother's ability to parent could be affected by her other mental health issues if they were not being properly treated or mother was not taking her prescribed medication. And there were several times documented throughout the exhibits where mother did discontinue the use of her medication throughout the custodial episode. But looking at the intellectual disabilities for both parents, Dr. Berryman opined that mother could not parent the child, and that for both parents, that they would need continuous parenting instruction throughout the remainder of the child's life. So for each phase that the child goes through, the parents would need consistent instruction to adequately parent him. They could not do it on their own. And a good example of this for father was his struggle to understand the child's needs and emotions and how that relates to father's own emotions. Father, throughout the whole episode, insisted that the child hated him. Despite being told by several people on several occasions that was not the case, father still believed that the child hated him even at trial. It's been argued today that the department did not make enough efforts to assist with these mental impairments and did not attempt behavioral therapy with the mother. But this court has previously held in DCS versus MIMS that DCS is not required to make reasonable efforts to return a child to the home, even in the context of mental incompetence. And in Re Samuel R., which is cited in my brief, it was noted that Tennessee courts have rejected the argument that the ground of mental incompetence applies only when a parent has a condition for which there is no amount of intervention that can assist. Turning to the last ground, the parents also failed to manifest an ability and willingness to assume custody of the child, and that's ground 36-1, 113G14. There are two prongs to this ground. First, the parent has failed to manifest either an ability or a willingness to assume custody. Again, mother was homeless at trial. She had bounced between homes throughout the custodial episode, and none of them were ever appropriate. She waited until 2020 to begin therapy. She had not accepted responsibility for the child's removal and blamed others. She admitted to using cocaine and tested positive for such. She missed visits prior to trial, and DCS had lost contact with her by the end of trial. Father had refused to participate in the virtual visits, and he did not provide proof of employment or residence to DCS. He admitted to using marijuana, did not show up for a scheduled drug screen, refused an alcohol and drug assessment, missed a child and family team meeting, and told DCS that he was done and wasn't going to do anything else. And then the final prong, returning the child to the parent would pose a risk of substantial harm to the child's welfare. Neither parent could provide a safe and appropriate home for the child. Homelessness and drug exposure and refusal of services is simply not an option, and it's not safe or appropriate for the child. And father did not have a bond with the child. The only home the child had ever known was that of the foster parents, as he was removed from when he was just days old and had lived there for 3 years by trial. Removing him from this home to expose him to the parents' lifestyles would pose a risk of harm to his welfare. And then finally, as this court is aware, there are best interest factors to be determined after there are grounds met to determine whether termination of the parental rights is in the best interest of the child. The best interest factors have been amended, but since this petition was filed before that amendment, the previous set of the 9 factors still apply. And so I'll highlight just a few of those. Looking at factors 1 and 2 together, the parents both failed to make an adjustment of circumstance or a lasting change despite reasonable efforts by DCS. As previously stated, the parents simply remained unable to parent at trial. There were drug issues, missed visits, refusal of services, homelessness, and lack of contact between the two of them. And DCS did make reasonable efforts. DCS arranged for Omni Visions to provide parenting education, therapeutic visitation, and anger management. Omni assisted father with child support and Social Security services and helped arrange a psychological evaluation. Omni assisted mother when she wanted to transfer money to another card through the Social Security office. DCS created permanency plans, scheduled child and family team meetings, and initially supervised the visits before they became therapeutic. There were attempts to arrange psychotherapy for the parents in 2021. There was a drug screen conducted on mother, and another one attempted on father, which he did not participate in. And DCS transported the child to and from the in-person visits and worked with Meharry Medical to try to arrange alcohol and drug assessments. Factor 3, visitation, weighs heavily in favor of terminating the father's parental rights. Though he initially attended visits when they were still in person prior to the pandemic, he refused to attend once they became virtual. When he was prompted to enter a code to enter the Zoom call for virtual visits, he said, forget it, and he wasn't interested. He did attend some once they became in person again in the spring of 2021, but he still missed some visits and was late to others. For mother, she did much better with visitation. She consistently visited up until just a few weeks prior to trial, and she started missing some visits. And during those in-person, so turning to factor 4, the meaningful relationships. Father struggled to bond with the child throughout the custodial episode. Prior to the pandemic, he could not bond with the child, could not comfort the child during the in-person visits. Again, refused the virtual visits. And then the child struggled with both parents. Once the in-person visits resumed in 2021, the child would cry and was very nervous going to and from visits and would seek out foster mother for comfort. Factor 7, the physical environments of both parents were not appropriate for the child. Both parents had admitted to using drugs and mother had tested positive. Father had refused a drug screen. Father refused the alcohol and drug assessment, and mother was homeless, and father did not give proof of residence. Factor 8, without getting too much into detail, the mental status of the parents was still an issue. As discussed, Dr. Berryman opined that the parents would need continuous instruction throughout the child's life to be able to parent the child. And then finally, bouncing back to factor 5, changing the child's caretaker in the physical environment would negatively affect him. He was 3 years old at the time of trial, had always been in the same home of the foster home. He was thriving in their care. He was bonded with the foster parents, and their foster parents wanted to adopt him. Removing him from the only home he's ever known to return him to the parents who continued to struggle with very serious issues would not have been in the child's best interest. So because grounds were met and because the child's best interest was to terminate the parental rights of both parents, this court should affirm the trial court's decision. Thank you.
All right, thank you. We'll now hear from the guardian ad litem.
Thank you, Your Honor. May it please the court. I am Bruce Radick and have served as Khalil's guardian ad litem since the beginning of the matters before the juvenile court, and which began shortly after his birth on January 31st of 2018. Khalil has been in the same and only foster home from just days after his birth to today. The parents' rights were terminated by the trial court on August 2nd of 2021. Let me just state, I am in support of the juvenile court's ruling and the Department of Children's Services position that the court's ruling in terminating the parents' rights should be affirmed. The parents, Dusty Hayes and Henry Jordan, were given all opportunity and resources to resolve the issues and concerns of domestic violence, mental health issues, drug use, and instability in housing and income. Although the parents took some steps towards reunification, they were inconsistent in their efforts and outcomes, while continually placing blame for not getting their child back on the Department of Children's Services and the caseworkers, professional service providers, and even on the foster parents. Khalil has been in his forever and foster home to date for almost 4 years now. But Dr. and Miss Amber, the foster parents, have cared for and nurtured Khalil to become a happy, healthy, and wonderful child. They want to adopt Khalil. Any change from this forever home at this time would be devastating, physically, emotionally, and psychologically to Khalil, and not in his best interest. I, as guardian ad litem, seek permanency for him, which is in their home. The judgment of the juvenile trial court terminating mothers' and fathers' parental rights to the child should be affirmed. Thank you, Your Honors.
All right, thank you. We'll now hear a rebuttal from each of the appellants.
Your Honors, on rebuttal, I'd like to point out that Dr. Berryman stated that I don't believe she stated that it was just going to be tougher with the behavioral oriented therapy. It was not that it was impossible. It was just going to be much tougher. If you look at the answers where I cross-examined her in about 364 of the record, again, it wasn't impossible, but it was just going to be a lot tougher. And again, that was that may have swayed the trial court, but I want to point that out. She is a veteran expert witness. She said she'd had more than 100 cases, and I'm sure this court's probably familiar with her. But in any event, I want to point that out about her testimony. The other point is that the outbursts that happened and the entire permanency process was shaken up in March of 2020 when DCS when the parents went for over 1 year without being able to see their child other than by video. My client, there were some issues when they visited together, but those issues should have been taken care of and apparently were taken care of when the parents visited separately. My client had custody from day one until it was taken away when the child was about 3 days old. But those outbursts those were because you weren't able to be with your child in a meaningful fashion, because the only way you could do so was through Zoom. And so I believe that's a big part of it. My client struggled with a lot of things, but she's been very determined. DCS stated in its opening argument, we wish there were another way, and I think there are other ways. And so we are respectfully requesting that this court reverse and remand so that these parents can continue on their journey. My client can try to regain custody of Khalil. Thank you.
All right, thank you, Ms. Mack. There you go.
Thank you, Your Honor. And so with all of that said, when they say that my client refused services, Your Honor, I just wanted to be clear that my client, the only time that there was ever any testimony in regards to him saying, I can't get on Zoom, I can't do virtual visits, the baby doesn't even look at me. And there was even testimony by DCS, both Shannon Walls, that the child didn't even engage in those virtual visitations for longer than 10 minutes. And you heard my colleague, Ms. Amber, for the state that the child would look to the foster parent to console the child. There were problems in regards to why was the foster parent present for supervised visitations that the department is now calling therapeutic, although Ms. Walls testified she was not providing therapeutic visitations. That Ms. Walls also provided limited parenting classes for the father that was basically for anyone else. Dr. Janie Berryman said for low functioning people who, my client had a driver's license, DCS said they didn't know where he lived, but he had a driver's license, car insurance, paying his loan off, still resided at the same address, still to this day. And the department said they couldn't locate him. But then we get where the CASA worker said, well, she tried to reach out to the father who's been represented by counsel this entire time. His prior counsel before me was David Hines, who is now deceased. So we're hearing the department kind of try to throw everything to show at the last minute that they have clear and convincing evidence to prove their case. But they didn't bring Dr. Janie Berryman in until this TPR petition was filed. Dr. Janie Berryman didn't do her evaluations until 2021, at which time she basically stated that, of course, if the child doesn't have a bond, if the child hasn't had, it would be very difficult to do without having done this before. And what I'm genuinely saying is Dr. Berryman never said that they couldn't do it. She said they needed help. They needed the services. They needed one-on-one parenting with someone supervising them with this child to make recommendations. And if the court will take judicial notice that there was never anything filed to suspend these the parenting time with my client, even the mother. And in fact, we tried to continue this on. Shannon Walls never testified that there was problems during those visits. In fact, her testimony was that the visits were going, the parents were working with her. And so again, we never had to where they progressed towards anything else, but then we get an expert that comes in and says, and looks with bare minimum evidence. Dr. Janie Berryman did testify. She didn't have everything to look at the entire case. She could only go on what was given to her. And she observed my client, the mother in court. She observed my client because he made the appointments and visits with her. And sorry, Your Honor.
All right. I want to thank you, Ms. Mack and Mr. Rose and General Barker and Mr. Radick for your arguments. We will take this matter under advisement. Mr. Hivner.
This honorable court is now in recess until 1 p.m.